like to welcome you to this joint Federalist Society ACLU series that we're partnering with the Dean's Office on promoting civil discourse, well as having some...
Wait a minute.
Oh.
Civil?
Civil? I gotta go. Sorry.
Civil discourse.
I thought this was trial by combat. I'm sorry.
Promoting, wonderful talks. So, some of you may know both of our organizations are partnering with the Dean, as I said, to promote civility and respect for each other and the rule of law. Today's event is entitled Presidential Immunity, the Impact of Trump versus United States. Before we get started on the discussion, I'd first like to introduce our speakers. So Professor Murphy said I had to make his bio shorter than Professor Blackman's, but I promised our
make mine even shorter.
What's that?
Make mine even shorter.
They're equal time, right? Wasn't that a thing? Josh Blackman is a national thought leader on constitutional law in the United States Supreme Court. Professor Blackman's works was quoted 2 times in the presidential impeachment
Back to back.
He has testified before Congress and advises the federal and state lawmakers. He regularly appears on television, including the NBC, CBS, ABC, Fox, and the BBC. Professor Blackman is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and other leading national publications. Since 2012, Professor Blackman has served as a professor at the South Texas College of Law, Houston, where he holds the Centennial Chair of Constitutional Law. He is also an adjunct scholar at the Cato Institute. He is a graduate of George Mason School of Law and clerk for Judge Kim Gibson, the Western District of Pennsylvania.
And
Louisville's own Judge Stanley Boggs, who's here.
Hi, Judge Boggs.
Today of the Sixth Circuit Court of Appeals. I don't think he knew he was making a cameo today.
He'll criticize me later about this one. Don't worry.
Professor Blackman has authored 3 books. His latest, An Introduction to Constitutional Law, which I suggest to lots of 1Ls and 2Ls when they ask for help on con law, was a top 5 bestseller on Amazon. He has written more than 6 law review articles and has been cited nearly 1,000 times. He was selected for 4.
That's enough. Go on.
Okay.
It's good.
Okay. Well,
No. I want to keep going. This is amazing.
Too much.
He was selected for the Forbes 30 Under 30 in the law, and Professor Blackman is the president of the Harlan Institute and founder of the Fantasy SCOTUS.
Ah, that's a good one. Named after one of Kentucky's native sons, John Marshall Harlan. One of my favorites.
The internet's premier Supreme Court fantasy league. He also blogs on the Volokh Conspiracy, where I read his stuff quite frequently, and his Twitter is Josh M. Blackman. He also, this is off of his thing, he's also quite the bobblehead connoisseur, I believe, as well. Professor Mark Murphy is
Well, for mine, you can just say his, but just say not in front of everyone. He has not been cited by the United States Supreme Court twice. He not only is not on Twitter, he's been thrown off Twitter twice.
And he sued Elon Musk.
Yeah. Anyway, go ahead. Sorry.
Professor Mark Murphy is a professor of practice at the University of Louisville Brandeis
I like
School
this
of
guy.
Law,
It's good.
trial attorney,
Okay.
and nationally recognized political cartoonist. As professor, he teaches criminal law, criminal procedure, and trial practice, and I'm not sure if I'm forgetting anything.
Civil procedure, white collar,
that's right.
everything.
Right, criminal law, he teaches it all. In addition,
If you get indicted, call him.
Unless you're the president, because it doesn't matter.
Then call me.
in addition to his course load as a professor,
We're gonna
of
need more
practice,
time.
He partners with the Office of Professional Responsibility to enhance the students' experiences, connections with the practice of law in Louisville and beyond. He is also taught undergraduate legal studies at U of L, University of Maryland, and Florida State University. He's a graduate of University of Notre Dame and U of L School of Law. As a trial attorney, he has nearly 40 years of experience as a prosecutor, criminal defense, and a litigator of complex civil matters, including class actions and frauds. He's also a Commonwealth attorney here in Jefferson County and was a judge advocate, General Corps member, and twice was awarded the Meritorious Service Medal. He also was Louisville's white-collar criminal defense attorney of the year in 2018. Professor Murphy is a nationally recognized award-winning political cartoonist, and his works can be seen in the Courier Journal as well as other print outlets. He's a member of the board of Cartoonists, Cartoonist Right Network International, and has delivered the 2023 inaugural McGarthy Lecture on Press Freedom at Murray State University. Okay. Today's discussion will begin with Professor Blackman giving a brief overview of the decision of Trump v. the United States and provide his remarks. Next, Professor Murphy will deliver his response. After Professor Murphy responds, both speakers will provide comments on each other's positions. Finally, the remaining 10 minutes will be reserved for questions from the audience. Again, thank you all for coming so much. Both the Federalist Society and the ACLU chapters are very excited that you are here. If you are interested in learning more about either of our organizations, there's a QR code you can scan for the Federalist Society. Unfortunately, both of our ACU officers are either in court or at an externship right now and not able to get here. If you do not know how to contact them, you can contact me and I'll put you in contact with those folks as well. And let's begin.
Thank you so much. This is a treat. So I clerked in Louisville for Judge Boggs in 2011 to 12. I've not been in this building in almost 12 years, which is a shame. I'm very happy to be back. I love Louisville. I mean that, and I love Kentucky. It's a second home for me. I gotta come here whenever I can. So you've all heard of this case, Trump against the United States. Which one, right? So this is the one about immunity. There are actually many cases by that name. And this was the case that concerned President Trump's conduct leading up to and on January 6th of 2021. The bottom line is the court granted immunity for some but not all of his acts. But I want to explain how we got there. And our story actually begins a long, long time ago, and actually plays not too far away, involving Aaron Burr. Now, you might know Aaron Burr as the person who killed, Alexander Hamilton, right? Relation of yours, maybe? Distant.
Hopefully not.
Distant, right? But Burr is also known for engaging in some very suspicious activity. Indeed, he was indicted on charges of treason. The allegations are actually vague, but it seems that he tried to maybe take parts of the United States territory and maybe raise up an army against the United States in the Western territories. Allegations are vague. But why is this important to our story? He was actually charged with treason in federal court in Virginia. And who presided over that trial? John Marshall, the great Chief Justice. And during the trial, Aaron Burr wanted a subpoena issued to President Jefferson. Now, Jefferson and Burr did not like each other. They were rivals by that point. And Burr said, aha, Jefferson, you have some evidence in your possession that could help me, right? That might say I'm not guilty. And in the Constitution, it says that if someone has some evidence, you can use the courts to bring that evidence forward. You get process, right? Okay. Did Thomas Jefferson comply with that subpoena? Not really. And this is a fun story. Jefferson basically took the position that, well, I'm president and you can't issue process against me. And Chief Justice Marshall wrote an opinion saying that, well, the president is subject to process, but didn't actually make Jefferson deliver the paper. And what Jefferson did was he delivered a redacted version of the document with parts sort of cut out. That's not complying with the subpoena. And that decision sort of just stood as the basis for what we call immunity. That there was some sort of immunity against the president for some judicial processes to obtain a document in a criminal proceeding that affects someone else. All right, now we jump forward to another president who was not very popular, Richard Nixon. I jumped to the day of June 17th, 1972. Judge Boggs, what happened that day? Of course he knows this.
Wait,
Watergate.
Are we cold calling?
Yeah, no. I see. He's an encyclopedia. You don't need Chat GPT. You have Boggs, a DJ, right? It's all up there. So yeah, June 17th, 1972, of course, is a break-in at the Watergate Hotel. To this day, we don't know exactly what that was about. The headquarters of the DNC were broken into. They found some documents. They took some stuff. If you were so Forrest Gump, you saw them, the lights flashing in the windows, right? But the upshot is that President Nixon later became aware of this break-in. If he knew about it in advance, not clear, but he became aware of it later. And there was a so-called cover-up, because there were some ties between the break-in and his administration. Now, the reason we know all these things is because Nixon had a tape recording system. He was not the first president who had that. I think Johnson had it, Kennedy had it, I don't know if Eisenhower had it, but at least a couple of the presidents had recording systems in the Oval Office. And at least Nixon thought, this can be used to hurt my enemies, right? I can record stuff and perhaps use it against people. He never thought it would be used against him. Why? These are my tapes. They're in my property. There were a number of prosecutions of various members in Nixon's orbit. People went to jail. But some of these defendants said, aha, I want evidence, right? I want those tapes, which could be used to perhaps exonerate me, maybe shift the blame to other people. So again, this case went to the U.S. Supreme Court in a very complicated fashion. Why? You had a special prosecutor who was working for the U.S. government trying to seek a subpoena against the president, the head of the executive branch. Nixon argued, what are we doing here? This is a branch dispute, right? It's within the executive branch. The courts have no power to resolve a conflict between a prosecutor and the president. But in a very important decision called U.S. v. Nixon, 8-0, Rehnquist had recused, the court said, no, we can hear this dispute. And the court ordered Nixon to turn over these tapes. So again, you have the John Marshall precedent saying that, yes, Mr. President, you have to produce these documents, and Jefferson said, not going to do it. And then you have almost 100-something years later, you have Nixon against the Supreme Court. Supreme Court says, turn the tapes over, and then Nixon delivered the tapes. So one decision may suggest a broader immunity, but the Nixon case said, well, no, there's no immunity here. These are documents in the president's possession. They later hold these are actually government property and hand them over to the courts. All right, now let's fast forward to 1982 with a case called Nixon versus Fitzgerald. A lot of Nixon cases. We'll get to Trump in a minute. Nixon Fitzgerald involved what's called civil immunity. Right? Here you had President Nixon was in office, made some comments about a person who was a civil servant, and he didn't like these comments. And then years later, Fitzgerald brought a lawsuit against Nixon saying, aha, you wronged me. I want some damages. So again, Nixon was not in office, right? He was out of office. But the basis of the suit was for stuff Nixon said while he was president. The court established what's called absolute civil immunity for civil damages. Absolute immunity for civil damages for official acts. That if the president's engaging in an official act, there's immunity. And the court defined this actually quite broad. They said the immunity extends to, quote, the outer perimeter of his duties. Whatever that is, the curtilage, right? The outer perimeter of the president's duties. This was a very sweeping decision which had dissents. And I won't pretend this decision was well-reasoned. They kind of just said, look, the president can't have these sorts of lawsuits against him after he leaves office because that could chill his behavior, right? He might be afraid, if I do this, I may get sued later. Okay, why does this matter? Because Nixon v. Fitzgerald is the law. It was not asked to be overruled. That's the law. Next case, Clinton v. Jones. We're moving right along. Paula Jones brought a civil action against President Clinton for stuff that he allegedly did when he was governor of Arkansas, sexual relations and other things, right? Clinton said, you can't bring a lawsuit against me. I am the sitting president. You can't do that. The court said, oh, no, yes, you can. These were acts from before he went to the White House. There's no immunity, and they'd be subject to civil process. And Justice Stevens wrote the majority and said, we're not worried that litigation will burden the president. This hasn't happened before. We're not worried about this. That did not stand up to the test of time. So again, so we have these cases. We have the subpoena against Thomas Jefferson, right? We have the tapes case with Richard Nixon. We have the civil case against Nixon establishing absolute immunity. And then we're saying you can be sued when you're in the White House. None of those cases address the issue of criminal immunity for a very obvious reason. Before Trump, no president ever been indicted for a crime, right? Or former president been indicted for it. It hadn't happened. There's some allegation that was President Grant got it's actually true, a speeding ticket. I think he was on a horse and buggy and he was going too fast. Judge Boggs is nodding. I think I'm right about that. So I think that's a misdemeanor of some minor offense. But can you imagine the cop pulling over the president in a horse and buggy? But that's how it went back then. Reconstruction, crazy times, right? So then we go forward to President Trump. And you were all alive for this. You weren't alive for Nixon or Clinton, I don't think. But you were alive for at least the Trump years. It was a wild time. And almost immediately after Trump came to office, litigation was just blowing up. So the first round was called the Emoluments Clauses. Do you remember this? I did a lot of work on this. It said, President Trump is accepting cash payments for these foreign companies through his hotels, and this violates the Constitution's Emoluments Clause. There's all this litigation. There was litigation to get his tax returns. Remember this obsession about his tax returns. There was the New York District Attorney was seeking his tax returns. Various House and Senate committees were seeking his tax returns. And look, they had reason. We want to craft legislation of how to, about tax. No, they just want to see Trump's dirty details, right? This was meant to embarrass him. And this was going on for years. And then, don't forget, Robert Mueller. Remember him? Early in his administration, Trump fired James Comey, who was the FBI director. This triggered the appointment of a special counsel named Robert Mueller, who investigated everything, it seems. And Trump was saying, no, you can't do this. You're out of bounds. Leave me alone. You can't prosecute. These are official acts. You can't investigate the firing of an official. Mueller ultimately never indicted Trump. He probably wanted to, realize it wasn't going to work, but he issued this report saying, well, I would have indicted him if I could, but I can't, so I won't. And that's kind of the Cliff Note version. But throughout the entire Mueller investigation, there was an issue in the background, immunity. Was Trump immune from firing Comey? Relatedly, were the various things Trump said about the firing subject to criminal investigation? Could that evidence even be considered by a jury? So a lot of the issues that came up in the Jack Smith case were actually lingering for much of the Trump eras. All right. Now we go to the 2020 election. Trump does not win, but then January 6th happened. You all know what happened. You were all, maybe, Dean, were any of the people there from at January 6th? No? Any of the students at the rally? I don't think so. No. Okay, good. Just checking. Okay. So you watched it on TV, right? The guy with the Viking hat putting his feet on Nancy Pelosi's desk. You remember this stuff, right? But that morning, President Trump gave a speech, and he said, you need to march to the Capitol and fight like hell. He also said you should go peacefully, right? So lots of things were said that day. On January 6th that evening, I was sort of seeing the thing, they're going to try and get him an insurrection. And I actually spoke out that night, said they're going to try to get him an insurrection, and they're going to try to say that his speech was not protected under the Brandenburg Standard. And that triggered just this will he or won't he? Like, what will Merrick Garland do? You know, and by the way, Merrick Garland, what a tortured soul, right? He was so close to the Supreme Court, didn't get it. He was appointed as AG to bring back unity to government, and his first decision was, do I indict the former president? That was his first decision to make, and he just sat on his hands for a long time. He indicted some other people, the Proud Boys and the Oath Keepers, on seditious conspiracy. No one was indicted on insurrection. Hasn't happened to this day. But then eventually, Garland appointed Jack Smith as special counsel. Who the heck is Jack Smith? He was not holding any government office. He was actually in The Hague prosecuting war criminals. And that's what I think of Trump, right? You bring the guy prosecuting war criminals to go after Trump, right? And Smith brought 2 indictments against Trump, one in Florida, one in D.C. The Florida case concerned the documents held at Mar-a-Lago. Remember, the boxes stacked in the bathroom, right? That case is still kind of moving on. I filed an amicus brief in that case, so I have some thoughts on it. But the big event was actually the J6 case. He brought charges against Trump in Washington, D.C., and the accounts were not for obstruction, I want to make sure I get this right, conspiracy to defraud the United States, and conspiracy to obstruct official proceedings. Right? What was the gravamen? What was the basis of this charge? They said, well, Trump is responsible for the disruption of the vote counting on January 6th, that he told his supporters to go up there and disrupt the counting. He also allegedly told Mike Pence to not count the votes or to maybe take a pause or various things. So there are a lot of allegations that concern Trump's actions, both as president and as candidate. Why does this matter? If there's immunity for official acts, then a lot of that stuff gets knocked out, that you can't consider it. But Jack Smith in the first go-around cast this very broad conspiracy that said, we're going to throw everything in the kitchen sink in there, and we'll see what sticks. That was a decision he made, right? You're a criminal lawyer. When you're the prosecutor, you choose what to put in your charging document. You don't have to throw everything in there. In fact, if you can get a conviction on less than everything, sometimes that's smarter. But Jack Smith was like, no, I want to create a test case that will weaken the ability of prosecutors forever. And that's what he did, right? It was a risk, right? He didn't have to bring that indictment.
I don't think that's what he said.
No. He didn't say that. But it was a risk. And again, he was acting independently of the Attorney General. To be very clear, it's not clear the AG even authorized the indictment. They've actually been very cagey on this point. But Jack Smith, who's this quasi-independent prosecutor, so under the supervision of the AG, said, we're going to bring this broad indictment. The district court allowed the case to go forward. Judge Shutkin in D.C. had a very noteworthy example. She said, wait a minute, let me get this straight. Let's say that the president orders SEAL Team 6 to assassinate his rival. Is that kosher? Right? Is that okay? Actually, the lawyer for Trump said, well, yeah, that'd be okay. I think that's probably the wrong answer, but he had to hold the line. Sometimes lawyers have to hold a line that's not very popular. You have to hold the line. And by the way, judges ask crazy hypos all the time. It's like, Judge, that's not what we have. We don't have any assassination attempts, right? But judges like these hypos because it tests the limits of your theory, just so you know this. It went to the D.C. Circuit. The D.C. Circuit sat on the case for quite some time, actually. They took their time with that case, and that made it very difficult to try Trump before the election. Smith tried going to the Supreme Court saying, please, take this case sooner, and the court's like, go away. Hopefully you never come back to us, right? But eventually the D.C. Circuit ruled. It goes to the Supreme Court. All right, the case is argued and decided in a fairly short span, about 3 months. And the court, to be honest, does not do their best work when they move quickly. It's just simply not the case. The Youngstown case, which I'm sure you've all read in common law, was decided in the span of a week, right? The best work is not done quickly. All right, so what happens? The court splits 6-3-ish. I say ish because Justice Barrett, it's not entirely clear where she is. I'll get to Barrett in a minute, but it's 5-4, 6-3, depending how you want to count it, okay? And Chief Justice Roberts, when Roberts wants to be clear, he's very clear. When Roberts wants to be opaque, he's very opaque. When he wants to hold a majority, he can be hold a majority. Here, he had his 5 votes. He didn't care about Barrett. So he was going to go all in. And he actually wrote, I think, a very broad decision for executive power immunity. In fact, I wonder if Smith had the benefit of hindsight, would he still have brought this case so broadly? All right. And Roberts sort of channels Justice Jackson in the Youngstown case. Remember, Justice Jackson had these 3 zones, right, of presidential power, that when the president has his own powers, plus the powers of Congress, he's at its apex, its zenith, right? And then there's sort of this middle area where this zone of twilight, I love Jackson, this zone of twilight, where it's not really clear where the president's powers are and Congress's powers are, and we're not really sure. Then the bottom rung is where the president has only his own powers, but not the powers of Congress. Congress said, no, don't do this. And as I read Roberts in the Trump immunity decision, he's channeling Jackson. This is not an original decision. I will not defend on those grounds, but this is a functional decision. And I think this decision follows in large part from Nixon versus Fitzgerald. By the way, no one asked to overrule Fitzgerald, so that was the basis. So Roberts has, again, these 3 sort of categories of presidential conduct. He says in the first category, where the president exercising core, as he says, core presidential powers, it's absolute immunity. You cannot regulate that. You cannot criminalize core powers. It's exclusive, he says. Then he said there's this third, I'll come back to 2 in a minute, this third category for what he calls private or unofficial actions. Private or unofficial actions, there is no immunity. Okay? But then the one that everyone cares about, the one in the middle, right? Even the prosecutor admitted that when the president's acting in his core powers, you can't criminalize, right? Imagine the president's indicted for vetoing a bill. No, you can't do that. That's the president's power to veto a bill, right? By contrast, let's say the president walks inside the Oval Office, goes to Fifth Avenue, and shoots someone, right? Okay, that's not an official act. There's no immunity there. The middle one is where all the action happens. So there are going to be some official actions that are outside of the core constitutional powers. And here the court labels it presumptive immunity. Dare I say qualified immunity. You know about QI. He knows about QI, right? Qualified immunity is this doctrine that exists everywhere. That if you're a police officer, for example, and you engage in an act of violence against a suspect, can you be sued for damages? Well, it sort of depends, right? Is there some sort of clearly established law saying you can't do this? If there is, okay, they can hold you liable. But if it's sort of we're not sure, you can't hold the officer liable. So the court says there's at least a presumptive immunity from criminal prosecution for acts within the outer perimeter. There's that language again from Fitzgerald, the outer perimeter of his official responsibility. And the court will grant this immunity unless the government can show that applying the prohibition would pose, and here's language from the lower court, no danger of intrusion on the authority of the executive branch. In other words, if we criminalize this act, will this affect the executive branch? So this is a fairly broad reading of immunity, but I think it follows both from Youngstown and from Fitzgerald, neither of which were being asked to be reconsidered. Now, where did the court split 6-3-5-4? It involves evidence of all things. Justice Barrett was a law professor. She taught evidence. She knows rules of evidence. And she says, wait a minute. If the president had all these actions, right? Okay, you can't criminalize those actions, but you can introduce them as evidence for other stuff, right? You know, related bad acts or prior bad acts, so to speak, right? The majority says, no. You can't even introduce as evidence things that fall within this perimeter, which will make it harder to have a conviction if you have to say, oh, you can't consider this, consider this. Barrett says, wait a minute, Rule 403, right? You guys know Rule 403? Rule 403, just we balance it out. We don't have anything that's prejudicial to the defendant. Majority said no go. All right. But then we have the dissent, which was by Justices Jackson, Sotomayor, and Kagan. And they were extremely troubled by the majority. I'm putting it mildly. They basically said this creates a person above the law, that the president now beyond the scope of any sort of process in criminal law, and there's no basis for it. And to be clear, I don't disagree with them, right? Nixon versus Fitzgerald didn't explain this as an originalist matter. It didn't. You know, the Jefferson immunity case wasn't really an originalist decision either, although it's from the 1800s. The court was being functional, and they do that sometimes. As a practical matter, though, and Gorsuch has made this point, unless you ask us to reconsider Fitzgerald, it's hard to go any other direction. Now, why did the court, I'll sort of move on to my sort of commentary now, why did the court issue such a broad ruling? I think Roberts and the others were worried about where this sort of lawfare leads. You know what the lawfare? Using law, legal tools as a way to punish politicians. They've witnessed Mueller. They've witnessed 2 impeachments, which Roberts presided over one of them, right? They witnessed the emoluments. They said, wait a minute, we need to take the courts out of politics, right? We don't want the courts to be another tool to knock political candidates. Take a step back. The leading political candidate who's more or less tied in the polls could have been put in jail any day now by a New York judge, right? There's a lot there that's significant. So I think the court was saying we need to be careful. There's another angle that maybe people haven't thought of, but Alito did. During arguments, Alito asked, what happens if the president tries to throw his predecessor in jail? He wasn't talking about Biden putting Trump in jail. He was talking about Trump putting Biden in jail. If you remember, Joe Biden had a special counsel appointed for his documents, which he kept in his garage in Delaware. Why was Biden not indicted? The report said because Biden was old and feeble-minded. He didn't remember anything. Little do we know, right? Biden says, of course I'm feeble-minded. Okay. No, opposite. Of course I'm not feeble-minded, right? Of course I'm. Look who's talking.
Freudian slip
Yeah, yeah.
here on camera.
It's okay. But Biden took umbrage at that, saying, of course I have full mental faculties. Okay? So what happens if Trump wins in 2 months and his DOJ indicts Biden for possession of documents, the same charge Trump had? What if he goes after him? And by the way, Biden was a former vice president. What if Trump decides to indict Biden on criminal conspiracy with his son? I mean, who the hell knows, right? I think even those in the majority realize this is a dangerous game to allow current administrations to indict their predecessor and perhaps future running opponent. Whatever you think about Trump, this leads to a weird place. Now, the other side, which I fully acknowledge, is they argue that Trump engaged in a crime. I mean, at least in the Mar-a-Lago case, he had those documents in his possession, right? He was a former president. He had no immunity there. The J6 stuff, there's some stuff that might be criminal, might not be. So it's actually there's not an easy answer here. And the Chief Justice, for all of his warts, which there are many, basically said, no mas. Let's get out of this mess. I don't want to do this anymore. You guys figure out this politics stuff yourself. I don't have to preside over any more impeachments. Leave me alone, right? That's John Roberts saying, leave me alone. And the dissenters said, we will live to regret this decision. This will be a mistake. Now, as a coda, as an aftermath of this decision, what actually happened? Jack Smith did not proceed with the original indictment. He issued a slimmed down indictment. And he took out a couple key things. He took out any sort of allegations that Trump instructed members of his DOJ to do stuff. Jeff Clark, another Boggs clerk, perhaps not, who's not on the stage right now, but all mentions of Jeff Clark were removed from the indictment. They also took out some of the communications between Trump and the Vice President Pence, not all of them. There's actually a funny quirk where it's actually the President of the Senate presides over the counting session, but that's his role as President of the Senate, not the VP. So we have this skinny, slimmed down indictment, which I think, and maybe Mark might agree, I think may pass muster in the court's decision, probably will. And if that's the case, what are we arguing about? In other words, if Smith could have brought an indictment with the exact same 4 charges, which will yield the exact jail sentence with fewer allegations, then what are we arguing about, right? If the court's decision gave Jack Smith a roadmap of how to get Trump indicted without trespassing the Article 2 powers, who cares? Now, why does it does matter? Timing. If Trump wins, his first action will be to say, adios, Jack Smith, farewell. Don't let the door hit you on the way out, right? Bye. This is over. He will probably pardon all the J6 people, including himself, if that's even legal, and we'll never hear this ever again. But if Harris prevails, this case will go forward, and we'll probably have another Supreme Court case next year. But at that point, who will care, right? Trump's out of office. He's not going to be a candidate. People just won't care about this, which might actually make it a more sober way of resolving a separation of powers dispute, not to sort of affect the outcome of the election. All right. That's all I got. I welcome to hear from Mark and hopefully from your questions later. Thank you so much.
Thank you. And also, thank you to the Federalist Society for bringing in Josh. I mean, this is, as they say in show business, which, after all, this is what this
Performance.
is. That's a big get and fabulous. And it's a privilege to be here with you. Thank you for your time here. We disagree. And among the points that we disagree about is that where you say that Justice Roberts says, and you may be right about that, where he says, there's not an easy answer here, and just leave me alone. I no longer want to be involved here. And then the further thought that really what will it matter if Trump loses the election? You were asking about whether or not Trump would, for instance, whether possibly President Trump will pardon people, whether he'll fire Jack Smith. And the first question that came to my mind is, would that happen before or after his coronation? In other words, would that be from President Trump or King Trump? And it may sound like I'm exaggerating, but as you know, I'm just echoing the dissents of Justice Jackson and Justice Sotomayor, with whom I utterly agree. I think that Justice Roberts did have a choice. I don't think that obviously he made the right decision, that the majority issued the right opinion. And I think that there is an easy answer here. Because I can very easily, and I come at this from a different perspective. I come at this from a decidedly non-academic perspective. I think Josh probably wrote a law review article in the Uber on the way from the airport here to this meeting. And so, but I come at it from the perspective of having been a prosecutor practicing defense law and having been involved in politics for these 4 decades. And what I see, and the thing that struck me when I read the opinion, among the things that struck me was the fact that Justice Roberts could have quite easily begun the entire opinion for them on behalf of the majority by saying, it's beyond question that in our United States, criminal conduct by the president, whether in office or not in office, is not part of his core responsibilities under the Constitution of the United States. End of opinion. Not sure it could have been a slip opinion, but it could have been much shorter. The fact that he took 110 pages, well, he took however many pages, gave some to the dissent, to, I think, perform a magic trick. I think that he, as most accomplished magicians do, he had us looking one place.
He's very good at that.
He had us looking one place when what he was doing was something else.
I agree.
And I think he quite specifically did something else, and I think he quite specifically did something else because he chose to do so because he wanted to protect this president. I take a very, very bleak view of the Roberts Court, and I have an awful thing to report, and you teach law school, and now I do this too. And I asked a classroom full, 60 second and third year students last year in the spring semester about their faith in the rule of law and their faith in the Constitution and their faith in the Supreme Court's ability to fairly and equitably render decisions based upon those rules. And quite differently from when I was here, long before you were born, but back in the 70s and 80s, the class almost uniformly agreed with each other. I didn't suggest an answer, although they probably knew where I was coming from, that they had no faith in the United States Supreme Court. And that was a very troubling thing for me to hear. Again, I didn't prompt the answer. These are future lawyers in our system who are telling me 6 months, or as I joke, you're 5 minutes away from graduating once you're a third-year law student. And you act like it. I understand that. I don't expect you to do the reading. And here we are. and you're telling me that before you swear an oath before the Chief Justice of the Supreme Court of Kentucky or Indiana or Montana or wherever, that you actually don't believe in the good faith of the United States Supreme Court. And I think that a decision like this by Justice Roberts is the exact reason why that's the case. Because he could have said, I'll get back to the magic trick. He could have said very easily, no, this is, he could have said, a crime can never be part of the core responsibilities and therefore absolutely immune when it's committed by the President of the United States or someone else. And then what he did in terms of this magic trick is he has us focusing, using language and references that are well known and better known by you and constitutional scholars, which I'm not, but to say, obviously you have the separation of powers and you have the role of Congress when it comes to the interplay of this separation of powers. And he made us read and made us then think, Justice Roberts did, that what we have here is a situation where Congress is criminalizing conduct by the President of the United States. And we don't do that. Well, when I read that for the first couple of times, I thought to myself, that sounds like he's arguing that it was criminalized ex post facto, that it was criminalized after the fact, when in fact, Congress didn't do anything to this President of the United States. What they did was, a long time ago, wrote these laws that he's accused of violating. So he has us looking there, and then he focuses on, when he talks about the three perimeters of analysis, he has us focused on, quite effectively, where the conversation took place and to whom the conversation was had. In other words, I had a conversation with the Vice President of the United States in the Oval Office. I told him to send SEAL Team 6 to get his boys together and go kill my opponent, and the court concludes that would be okay, effectively concludes that would be okay, because of where he did it and to whom he was speaking, and because Congress can't criminalize the conduct of a president. The other thing he did, which was very insulting to me as a lifelong practitioner, was he took the matter, and I think took the criminal case, and well, I know he took the criminal case, and took the rule of law out of the hands of the people. And there's something that always comes to me when I was involved in politics and when I'm reading cases and now teaching, and that is when it comes to elected officials, that's frequently forgotten. And we have had an imperial presidency for some time. I think that's fair. And something that always comes to mind with me, though, is you work for me. You work for us. And us, me, everybody in this classroom, everybody in the city of Louisville is bound by these laws that Congress wrote. And everybody, if they were indicted, would be subjected to the same court system. And this is what's insulting to me about what Justice Roberts wrote. And it's how he wrote it. And it's a little bit of attention to detail, but I mean, I know you picked up on this, but probably most people wouldn't. But he was talking about what would happen if you subjected the President of the United States to a criminal prosecution, like you would any other citizen, which, by the way, is exactly what should happen in ways that I'll talk about and the ways Justice Jackson outlined. Justice Jackson, notably, the only person who's practiced criminal defense on the United States Supreme Court. So she's obviously going to pick up on these things. You mentioned Justice Barrett having been the only person who taught evidence, perhaps, and I feel that way about Justice Jackson. But he wrote the phrase in derisive terms, I believe, it can't be taken any other way, that if you subject the president, generally the words are, well, I know the specific phrases, but he's talking about subjecting the president to criminal prosecution. He says, well, are we going to rely on a trial judge's quote, and he put these phrases in quotation marks, jury instructions, and are we going to rely on the trial judge's evidentiary rulings, he said, in his opinion. And he put those two phrases in quotation marks. It's not a direct quote from any brief. It's not a direct quote from any statement. And for him to do that is a way of infantilizing the criminal justice system. He did that in words, and then his decision does this in action. And this is another thing that's offensive to me and very dangerous to me about this, is that he sends it back to the court with this elaborate process, which is still gray and difficult to describe. Jack Smith is going to try to work his way through that, about how you handle a criminal prosecution of the President of the United States, when, as you know, my premise is you don't need to handle a prosecution of the President of the United States in any way different than you would of me or Dean Coel or anyone else. Dean Coel has done nothing wrong. I want to make that clear for the record, that we know of here.
That we know of?
That we know of. And she would call me if she did. I think that's fair. And we would call you for legal advice. But the thing is, it goes back to the court with these instructions to determine which part of these concentric circles the president acted in. And it's unnecessary. That's utterly unnecessary. And even there, it's treating the president in a way that a citizen wouldn't be treated, because no man or person is above the law. The ordinary person goes through the process that Josh described, where a prosecutor reviews the evidence, takes her time, and then ultimately decides whether or not to prosecute. It's not up to her alone. She has to convince a grand jury. Then the grand jury issues an indictment or not, and then it goes before the judge for pretrial motions, as it should. And then ultimately, the people who decide whether the President of the United States, as they would a pro bono defendant, a pauper in federal district court, would be us, the people. And Justice Roberts has flipped that script. By making fun of jury instructions and making fun of the evidentiary rulings of the judge, he's saying, you are not capable. You're not good enough. You're not equal enough. We aren't any longer the United States that we're going to allow the presidency the president's conviction to rely upon your processes. Another angle that Justice Roberts takes, which is something that also you see in the Fitzgerald case, and it actually comes up in all the Nixon case and the Clinton case and the Fitzgerald case, it's the burden upon the presidency. Now that burden upon the presidency is expressed in these cases from the Supreme Court in ultimately different ways. Usually though, you can frame it, and you may disagree with me, but you can frame it as, this is a really big job that we've given this guy. He's a really important person, I won't deny that. He cannot be distracted from doing his job by, for instance, responding to these subpoenas or by talking about the sexual intercourse or he may or may not have had with Paula Jones and all these other things. Two things about that. First of all, where it comes down to in this case is not because President Trump is any longer a sitting president, he's a former president. But the argument that Justice Roberts makes is, if we allow Donald Trump to be prosecuted, that's going to have a chilling effect on future presidents' job while they're president. Because he says, in not so many words, they'll always be looking over their shoulder to see if they're going to be prosecuted. What I say, and what Justice Jackson says, is good. That a president of the United States, just like me, just like Dean Coel, just like anybody, a citizen here in this country should be looking over their shoulder. Now, most of you, in your ordinary lives, coming back and forth from the parking lots and eating lunch and going to class, you're not worried about the government looking over your shoulder and being prosecuted. You know why? Because you're not committing any crimes. We need our president to be looking over his shoulder. And if it's a burden, as somebody who's represented a lot of people in criminal court and understand what a wreck it can make of their lives, and it is a burden, it should be a burden. But if it's a burden, it's because you're being prosecuted because the system has worked in that regard. Justice Brandeis, our own Justice Brandeis, quoted the English author to say that power corrupts and absolute power corrupts absolutely. And I take a very strident approach to this with regard to the president. I do believe that he isn't simply, and you guys who have had me in trial practice, you know I always talk about the people on the opposing side being simply opponents and never the enemy. That's so important. We even talked about that in civil procedure, I think, the other day. I believe, and I know we're being recorded, that Donald Trump is the enemy. And I think that we're well past the time when, and I wrote a piece on this the other day where I said, we're going to, it's complicated, ourself out of our republic. The Republicans are playing for real. People who are on team Donald Trump are playing for real. And people on the other side who would oppose him are still playing chess. They're not just playing checkers, they're playing chess. But the Republicans are playing to win, and they've kicked the board over. And I believe that Justice Roberts has helped them kick this game board over. By the way, Justice Brandeis is buried outside. Did you know that?
I knew that, yeah.
We got a dead justice right outside, right out front. I mean, that's quite a thing to tell visitors. I'll conclude briefly, and then we can discuss, and I'd love to have questions. I know Josh would too. I think that Justice Roberts had an obligation. Instead of talking about what he did do or didn't do, I believe that he had an obligation to stop this here and now. And I believe, well, I don't believe, I'm positive, even without the constitutionally scholarly background of Josh, it was clear from the opinion when I read it first, second, third times that it wasn't obvious that he had to reach this result. That, yes, Fitzgerald, they didn't ask them to overturn Fitzgerald, but Fitzgerald's a civil case, and the criminal law is different, and our rules. We don't talk about somebody being above the law when you talk about civil law. That's always referring to criminal law. It's referring to the statutes that the legislatures have enacted before the actions were perpetrated that govern us. And I think Justice Roberts, in saying, leave me alone, I think he left us all alone. And I think that's a tragedy. And the other part of that tragedy is that it's not going to be fixed before this election. And so I worry. To quote a very distinguished jurist, I fear for our democracy. And I don't say that lightly. I'm not trying to be an alarmist. I'm not worried about being considered an alarmist because two of the dissents said the exact same thing. I think Justice Jackson said it's a 5-alarm fire. And I think that's the truth. And it took them a lot less to say those things than it did Justice Roberts to perform his magic trick where he had us looking the wrong way. So
Thank
those
you
are my
so much.
thoughts.
Thank you. You can see why he's a top-ranked criminal lawyer. You can see he's very, very effective. So a few points. So first, it's a common allegation that we don't have faith in the court. It's this MAGA court. Could I tell you what a MAGA court would actually do? If it was actually a MAGA court? The court ruled against Trump in all of his election cases in 2020. They didn't even consider them, right? The court ruled Trump had to turn over his tax returns. The court ruled against his census case. I can go on and on. The court was not particularly friendly to Donald Trump when he was in office. I can tell you, much to my consternation at times, trust me on this one. But this was not a court that was friendly to Trump, okay? The second point is I agree that John Roberts is a master of misdirection. Want to see an example? The Obamacare decision. This was decided when I was clerking for Judge Boggs a decade ago, right? Roberts always says, look there, but something going on behind the curtain, right? But what he was doing was grafting the Youngstown framework onto this case. All he said is that there are going to be some acts where it's not really clear if it's official, it's not really clear if it's unofficial, it's presumptive. On Zone 1 and Zone 3, Jackson, Kagan, and Sotomayor agreed. They agreed that for a core power can't be criminalized. They agree on that. And they agree that for an unofficial act, there's no immunity. They only disagreed on the middle part. So I think the distance between the majority and the dissent is actually smaller than it might seem despite the rhetoric. Now, on the point of saying a criminal act, how'd you phrase it? I want to make sure I get your phrase right. Sorry, he's writing. I want to make sure I get it right. That a criminal act, how would you phrase the opening paragraph? Right.
Yeah, yeah.
A criminal act, thank you. This is why it's a photographic memory.
I mean, I don't even remember what I said.
Yeah.
He remembered it.
So the trick is, let's take a statute like obstruction of justice, right? There's a statute which we all know. What's obstruction of justice? Well, we know it is in many contexts if you intimidate a witness, right? If you try to threaten a judge. What happens if you fire the FBI director? Because the FBI director is getting close to something that you did in the past. There's no clear standard on that, right? It's not clear. I think all 9 justices agreed that a clear act of crime, the SEAL Team 6 example, there's no constitutional authority to use a SEAL Team 6 to assassinate your rival. There's no authority for that, right? The president can't use military force on his own, and no statute authorizes that. It's not like the War Powers Act. You can't point to any authority at all. That's the reason why the SEAL Team 6 example doesn't work. It's nothing with immunity. But when the president decides to fire an FBI director, which is his absolute right to do under Article 2, who happens to be investigating him, how do you consider that? It's not a clear issue, right? I often wonder is, let's say in an alternate universe, John Roberts and Justice Jackson played Kumbaya and made a majority opinion together, right? Just imagine that. What would the majority opinion have been like, right? What would you have actually said when you're writing this opinion? Would you have just said, yeah, we do what the lower court did? The lower court had a very small space for immunity, which could have actually hampered precedent, frankly, of both parties in ways that might be, I think, frankly, are dangerous, right? I know you worry about imperial presidency, but I also worry about there's a Democratic administration, maybe that there's a special counsel appointed that tries to indict them on various things afterwards. So I think this opinion is harder to write than you might think. I do have faith in our republic. I do have faith in the future. Again, if you really want to see what a MAGA court looks like, come to Texas. You can see some of my beloved Fifth Circuit. Some of the decisions there are very conservative, and they get reversed a lot. This is not the court you're worried about. Now, maybe when you were in court in the law school in the 70s or the 80s, and people were back then.
It only took me 3 years. I wasn't there.
Fair. Fair enough. There were decisions by the Warren Court, which I can criticize for hours on end, but why? They were considered just. You want to defend Miranda as a matter of first impression? That decision had a lot of consequences, sort of made up of whole cloth, but it's now become part of the canon. I think people having faith in the court turns whether they agree with the decisions. I think it's actually a failing, frankly, of legal education and also the media to say if it's a court you disagree with, we have to attack it as being biased or unfavorable. We have to just attack the justices every 5 minutes. I think they do the best they can. This is a conservative court. You're not going to like it. If you get the votes, maybe you can expand it and dilute their votes, for example. That's what we have now. And I think it's a mistake to think these judges are just these partisans' robes. If they were, it'd be a very different court.
And I think I'll just briefly respond, and it's not even really a response, and then certainly we want to have time for questions as well. I think that how this works in practice, and Justice Jackson again did a really nice job as the former defense attorney and trial attorney of explaining what really happens here, and I think assuaging the concerns that Justice Roberts asked for us to look for after he popped smoke and waved a silk sheet. A person is indicted as the president, a former president. Case goes to court. Then the defense attorney on his behalf files motions. The judge rules on those motions. If those motions are ruled on in a way that's contrary to the defendant's interests or perspective, he can argue on appeal. Meanwhile, the criminal case moves forward. Then during the trial of the case, we talked about the evidentiary issues that Judge Barrett raised. Would things come in under Rule 4013B or not? Well, that's up to the judge, as it is in every case. That's a thing that I'm going to continue to repeat here. Then, importantly, even though Justice Roberts finds no value apparently in them, certainly in the role of when a president or somebody truly important is being prosecuted, the jury instructions are given by the judge. The judge tells the jury how to decide the case. And quite simply, there's no need for an elaborate new process by which the judges now have the most important role pre-trial, and it will never perhaps get to the judges decide what they always do, but in this case, whether the president himself is sent through the jury process. Ultimately, the judges decide whether something is part of the core conduct from the Constitution, as opposed to letting the jury decide whether there was criminal conduct. And the judge can instruct the jury as to whether or not they believe, very simply, those of you who had me in first-year criminal law, did the president have a criminal state of mind? These aren't specialty statutes. They're relatively easy to read. Did the president have a criminal state of mind, and did he act criminally? The defense counsel will file their own brief of instructions and ask the judge to instruct the jury whether or not the president is immune. The judge can decide whether he wants to give such an instruction. The judge will likely not and shouldn't give that instruction, and the case will then be appealed. The president will have been convicted properly as any other citizen, and then the courts of appeal can decide whether or not going back as the process should work, not beforehand but afterwards, is there in fact a level of immunity here? Not this new absolute immunity in some cases, but a new level of immunity. One of the things that Justice Jackson also mentioned, well, I'll move on from that. One final point, and that is that this discussion that we have here is almost literally an academic discussion because we're in academy and we're having a discussion. And basically, aside from me, everybody else here is a scholar. And so we're talking about this, and law review articles are being written about this. There's probably already a library full of those. This is an important debate. That's why the academy exists. However, I come at this from the perspective of the only thing that the people of the United States of America know about this decision, because the title of this program, I didn't write it, the title of this program was The Impact of Trump versus United States. I'll tell you what the impact is from my perspective, and that is that everybody who supports the January 6th insurrectionists think that the president is immune. They don't care about the 3 zones of influence and the 3 zones of the application of the Constitution and the degree of difference between what Congress can do and what the president can do. They understand now, not just in the past, but going forward, all these election officials in Georgia, all these election officials all over the United States that are getting ready for this next election and the possibility of a defeat by Donald Trump believe that the United States Supreme Court is on their side and has their back. And I think that that's true. Not that the Supreme Court is on their side and has their back, but that they believe it. And I think that's also as important as the legal arguments and as important as the academics, as the academic discussion. I think that's the real impact of this decision, that for the first time in my lifetime, it's a matter of accepted law. I think I can say this correctly, that there are circumstances in which the president is above the law. And that can never, should never have been, and can't exist as we go forward if we're going to continue to be the country that we are. I'll stop.
All right. I'll let him have the last word as,
Oh,
as a knob civility. I'm not above the law.
Do you want to call questions?
Yeah, you can call
Yeah,
people whatever you want.
yeah.
Just raise your hands, please.
Yeah, raise your hand and help.
I'll let you call people, Tim. Go ahead.
You want me to call people?
Yeah, go for it.
John.
Professor Murphy, what is your answer to the typo of the firing the FBI director that really looks like obstruction? Is that you look at it first as like, is it a criminal act, and then if it is obstruction, then it must not be an official act, or is there some other way to analyze that?
I think, and this is simplifying it for our purposes here, but I think that it's, as Josh pointed out, this is the first time this has come up with a president. It's the first time that a president has been accused of criminal conduct in this regard. It's the first time that the Supreme Court has had to make this type of decision. And so that doesn't happen. I mean, I have faith in elected officials from either party. I have a degree, we have to. If we don't have that, what do we have? And so when it comes up, rarely that a prosecutor and an AG, a U.S. attorney believes that a crime has been committed, there's no reason for that to move forward, for that not to move forward the way that every other criminal prosecution of every other person is. And the point that Justice Jackson made that I was going to allude to earlier is that the difference between a defense in a criminal case and immunity is a world. It's a galaxy apart. A defense is saying, I had the right to do this. I was authorized to do this. Here's the enabling statute. Here's whatever. That's how cases go. And again, we trust us because they work for us. We trust the jury. We trust the judge. We trust counsel. Immunity is saying, quite literally, the law doesn't apply to you. So that's where I come down to that. Judge Box. Oh, well, yeah, he's calling on you. Yeah.
No, let
Yeah,
the ju-
but how
let-
can we not call? Yeah.
Let the judge go. Yeah.
He's not above the law, he can call it.
Do you want to respond, or?
So I mentioned President Grant. I'll mention President Grant again. During his administration, there was a scandal called the whiskey ring, which I'm sure the judge knows all about.
Which we're all in favor of here in
Yes.
Kentucky. Yeah.
And it was actually involving duties and a collection of duties for whiskey. And actually, President Grant's administration appointed a special counsel to investigate it. And the special counsel got a little bit close to the president's secretary. And what did Grant do? Had him fired. This is as old as time. This is as old as time. It's not new.
Judge, I think Professor Murphy put it most starkly, the same quote that Josh was saying, that criminal conduct cannot be part of the core functions of the president. But the question is, criminal conduct is what Congress or any state legislature says that it is. Josh talked about history. If you remember, Andrew Johnson was impeached for violating the Tenure of Office Act.
Mhm.
Congress passed a law that said you can't fire the Secretary of State. As it happens, he was not impeached, but Congress could easily have made it a criminal offense and prosecuted him wherever. We know that President Clinton, on the way out of office, pardoned a man who was a fugitive, never tried, named Mark Rich.
Mhm.
There were charges, probably untrue, that he had been sleeping with Rich's wife. Now, Congress passed, or any state passes a law that makes
We
it
don't
a
need to give him the
violation
benefit of the doubt.
to sleep with the wife of a person that you pardon. That clearly has nothing to do with your official acts, easy. But suppose they say, anyone who pardons someone with whom they have been sleeping with their significant other within a year before or after shall be criminally charged. That would seem to be a core function. So the question is, I'm not saying the Roberts opinion was right, but the question of making it very simple, of shooting somebody, is Congress and a state legislature. Remember, we have criminal cases and courts in the states. The state of Alabama could criminalize half of what President Harris starts doing. So how do we deal with that? Do we leave it all to the
I'll
jury?
be very
You
brief.
can do this one. Go
I'll be
ahead.
very brief, and all of a sudden I'm in front of the Sixth Circuit Court of Appeals. So this is wonderful. adding this to my resume. So what I see in the things you said, Your Honor, is that you're referring to potential legislation that seems to me to very specifically target a particular office and that officer, like only the president or a governor can pardon. And so that's particular legislation, and I think that goes quite closely to the sort of discussion that Justice Roberts led his opinion with about the separation of powers. How I would distinguish what I was saying is that the statutes with which the president stands charged, apply to all of us. And that's, I guess, an easy line for me to draw. Anyway, go ahead.
I agree with the judge. Let's some more questions. I want to hear from students, please. Yes, ma'am.
So, Professor Murphy, do you think qualified immunity similar to what statutorily should be applied to the president? And then, Professor Murphy,
Yes.
It is.
you talked about how there are some acts in the gray for presidents that don't really have a constitutional basis. Do you think Congress can legislate a basis, or that the court must solely just rely on the Constitution for this question?
That's a good question.
You
Do
go
you
first.
want- So I mean, this was Youngstown, right? And you'll study this case. I'll mention it. President Truman ordered the seizure of the steel mills, and he said, "I have the power to do this because there's some statutory authority, and also I have the Article 2 powers to seize property." And the court said, "No, you don't. The statutes don't authorize this." If Congress were to pass a statute, to use Judge Boggs' example, saying that it is a crime to fire the FBI director, just use the exact example with Johnson, I think that statute would be unconstitutional.
Yeah.
Right? I think it would. Just because Congress says something is a crime doesn't make it something that is able to be a crime against the president. Now, the harder one is you have a general statute like obstruction of justice or obstruction of Congress. This is a statute that's not targeting the president. It was passed many, many years ago, but can be applied by a competent prosecutor to the president's actions. There's no way to know ex ante, that is in advance, if this when this power. So unfortunately, it comes to the court. Now, when does it go to the court? After a jury trial, conviction, and jail sentence, or an interlocutory fashion as an immunity defense. See, the key thing about Barrett is when you have an immunity defense like QI, it goes up right away. You don't even have a trial on the merits. You consider the legal question. I think there's value in having a legal resolution first before you put the guy through a trial and even having a jail sentence. I mean, the Trump New York case, the criminal one, that can go for 4 or 5 years before you get a final judgment, right? I think important is finality and prompt resolution.
He spoke for me.
Okay.
We've got time for about 2 more questions.
So, I guess what I'd like to focus on is just the partisanship, or like, I guess the allegations of partisanship of the court. And this question is for the both of you. So do you think that, assuming that Justice Roberts was trying to rule himself out of, and rule the court out of being able to be viewed as partisan by taking on all of these partisan cases, do you think that the court can effectively do that and kind of diminish how people view the court as partisan? Or do you think that the nature of partisanship necessitates that outside forces kind of put a boundary?
Go ahead.
All right, so I actually, you framed that in a very, I think, responsible way, so I thank you for that question. I distinguish between politics and judicial philosophy. I mean that sincerely. I spent a lot of time with judges. I talk to these people. I don't think they're being partisan in the sense they favor Team Republican over Team Democrat. What I do think they do is they have different philosophies of the separation of powers, which perhaps line up with the various political parties, but I think that's almost secondary. I think Alito in particular and Roberts, those two, they both served in the Reagan administration. They saw what it meant to having a nonstop investigation with Iran-Contra and Lawrence Walsh and all these other investigators going after the presidency, how it harms the executive branch's functioning. And I think they're worried not just about Trump, but also about what happened to Biden in a year or two. So I don't think they were there. Would it have been easy for them to say, wow, you know, I want to avoid political blowback. Let me, a Republican-appointed judge, rule in favor of Biden, or rule in favor of Jack Smith. That would have been even worse, right? Basically, to minimize the blowback, you sort of go against type and you vote against your character. So I think Roberts had strong views in this issue. He was very clear on this. I don't think Barrett was there all the way, but she was there probably 80% of the way. And they issued it. And these decisions are unpopular. We haven't talked about Dobbs, but I can talk about Dobbs. This was a decision that they knew would be unpopular. Someone tried to assassinate Justice Kavanaugh over it, right, to prevent the decision from being issued. Justice Barrett said she had to bring a bulletproof vest home that her kids saw her in a bulletproof vest. This is serious business. But I truly believe that all the judges, not just in the Supreme Court, but my beloved Sixth Circuit as well, they're doing the level best, and they're trying the best they can to resolve these cases carefully. If any of you intern or clerk for a judge, I think you'll see it. I mean, again, I clerked. We don't walk and say, hey, how do we help the Republicans win this case? That is not a conversation that will ever happen. I believe that, but maybe I'm being Pollyannish. Tell me why.
Well, I don't think it has to happen.
Okay.
Because I think, and it's clear in this decision also, very clear in this decision. I mean, Justice Roberts says several times, I think throughout the opinion, wow, this is a tough one, and there really isn't a whole lot of precedent that's helpful here. And then I think he draws conclusions that are inappropriately drawn, like civil immunity and the jump to criminal immunity, for instance. The burden on a sitting president by having to answer civil discovery versus, well, guess what, buddy, you've been indicted, and however, I think that we have to recognize, I certainly understand and know every time I go into court on a trial that's utterly unpolitical, I know who appointed the district judge in federal court who's trying my case. I know the background of the circuit court judges in Jefferson County who I'm trying cases before. I have an obligation, I believe, under the ethical rules to have those discussions. I think that if I fail to discuss what I believe to be political ramifications of our work in this courtroom, even if it's a murder case, even if it has nothing that on its surface isn't an overtly political thing, then I've malpracticed the case vis-a-vis my client. They need to know those sorts of things. And I don't think that it's a problem because the Warren Court, as Josh mentioned, had an agenda. I think it clearly did. I happen to have loved that agenda. And when I was in law school in the 70s and 80s...
Sorry.
And when I was in law school in the 70s and 80s, if you ever watched Happy Days, that was us.
Monday, Tuesday, Happy Days.
Yeah, exactly. I love a guy who can quote a movie or a TV show. I thought that that's the direction the court was heading, and I was very happy about it. As it happens, that was, in retrospect, a very small gap in what has generally been leaning in the other direction. But I will say, in contradiction, the opposite of what Josh said, I think that, like, for instance, the Miranda decision had an enormous impact on our nation and policing and our constitutional rights and how we think about our constitutional rights. And I teach criminal procedure. I can't put that in the same galaxy as the decision in Trump versus United States. So.
Okay, so we went a little over time. So
And if you want to ask questions, happy to answer questions up here.
Yeah, we'll be
questions afterwards. Again, everyone, please thank our guests.
They were great.
Yeah.
Speaking of the legitimacy of the courts, our next shared event with the ACLU
Perfect timing.
and the Federal Society will be on September 23rd. It will be a discussion on the legitimacy of the courts with Athy Libas and Professor Cassie Chambers Armstrong. So we invite you guys to come to that, and I believe that'll be at 12 noon and not in this room. I think
Can
275.
I'm going to take Dean's prerogative for 30 seconds because I really want to thank
Look at her sweating.
Tim and Josh, so
hot
the
in here.
Federalist Society and ACLU for
Yes.
reaching out over the summer to talk
Yes.
about this series,
Thank you.
to talk about the importance of collaborative events, to talk about the importance of civil discourse. This was phenomenal.
really
Thank
was.
you again, Professor Blackman
Thank you,
and
thank you.
Professor Murphy. This was so great, but thank you, Tim. Thank you, Zach. Zach got the door, I think.
He's out.
But thank
He's
you,
back.
and to Josh and Mallory from ACLU who
Thank
are
you, thank
busy
you.
working. In addition to the event September 23rd, we also are putting the final details on an event about bridging the gap Robert Stivers, who's the president of the Kentucky Senate, will be here, along with Morgan McGarvey, who is the Democratic congressman who represents our district but had been in the Kentucky Senate. That will be an event where they do a Q&A, and then we'll have a reception in the Cox Lounge, so more information about that. But all of it because the Federalist Society and ACLU are setting such a great example
Thank you.
for how we can talk about difficult things in a very respectful way.
Thank you so much.
That's law school.
And thank you to the students who
Thank you.
attended, and everybody who
Thank
attended.
you.
Very good. Thank you
Yeah,
so much.
love a guy who can quote a movie. So my problem currently is that